From the American Bar Association Law Museum in Chicago, the section of Antitrust Law presents the Oral History Project. Interviews with the leaders who have made significant contributions to antitrust law practice.
I'm Mark Crane. I was chair of the Antitrust section of the American Bar Association in 1986-1987. I'm here this morning with my friend and colleague in the Chicago Antitrust Wars, Dean Phil C. Neal of the University of Chicago Law School. And we're very pleased to have him here this morning to talk about his role in the development of antitrust law during the last half century and to give us some comments on the state of the law today. Phil, you grew up in Oak Park. How did it happen that you went to Harvard?
The dean of freshmen from Harvard College came through interviewing potential students. I had an interview, and very shortly thereafter I was told I had one of their most generous scholarships, and I decided to go. And I don't even remember ever applying to Harvard, and I certainly never applied to any other place. Life was much simpler.
And this was back in 1936?
1936, yes.
What was Harvard like while you were there?
Well, I loved the place then. I've had some second thoughts about it more recently, but I thought it was a great place. Very stimulating students to be with, as well as faculty.
You went right on to the law school then after that, the Harvard Law School?
I went right on to Harvard Law School, but in my first year I became ill with rheumatic fever and I had to drop out mid-year. And I didn't resume until the following mid-year. And in the first semester I took some economics in the graduate school.
And what did you do after law school?
I clerked for Justice Robert Jackson, and then I was with the State Department for a short time to become a member of the Secretariat at the UN conference in San Francisco. That took me to San Francisco. I stayed and practiced for 3 years in San Francisco.
Phil, can you tell us how you came to clerk for Justice Jackson?
Actually, his son Bill Jackson was a classmate of mine in the law school, and he told his father about me, and his father invited me to come down for an interview, and that was that.
No formal application process, I think.
Again, life was much simpler then.
And how long did you clerk for the justice?
Almost 2 years. I left before the end of my second year to join the State Department.
What was it like working for Justice Jackson?
Well, it was entirely delightful. He's a delightful man. He wasn't very demanding. It was stimulating working for him. It was interesting. If you wanted to, he'd put a draft of an opinion on your desk. And,
did he draft the opinion?
He did almost all his own writing. He would ask his clerks to review them and supply some footnotes and so on, and was very receptive to comments. But if you wanted to make any impact, you had to do it fast, because he would shortly say, well, let's shoot it around and see what the brethren think about it. And then when 4 others had concurred, he would say, well, let's not rock the boat now.
What did you do as a clerk beside review his drafts?
Mostly worked on cert petitions, prepared memos on all the cert petitions. And once or twice during a term, he would let his law clerk write a whole opinion. And I remember doing that. Then he might touch it up but do very little with it.
So your opinions are in the books virtually the way you wrote them?
Right.
Were any of those antitrust opinions?
No.
Were there any antitrust cases on the court while you were there?
The two that I remember were the Southeastern Underwriters case, which involved the issue of whether insurance was subject to Congress's commerce power, and the case of Georgia against the Pennsylvania Railroad. But he wasn't involved in either of them, as I remember. There were still cases coming to the court where he had some involvement as Attorney General, and he was disqualified.
How did it happen that you went to the State Department after you left clerking for Justice Jackson?
Well, Justice Frankfurter took a great interest in former Harvard Law Review presidents, and so he was in and out of my office fairly often. And he came in one day and said, "What are you gonna do when you leave the court?" And I said I had been not been involved in the war because I'd been sick and had rheumatic fever, and I was disqualified. And I thought maybe I would enjoy, or I would like to have something to do with the peace. And he grabbed me by the elbow and propelled me, as he was wont to do, to his office, picked up the phone and called Alger Hiss, and told Alger Hiss he had somebody that he thought Alger Hiss would like to have for the forthcoming work at the State Department. So the next thing I knew, I was in Alger Hiss's office, and I was hired, and almost immediately went to work for the State Department.
Still no application.
Still no applications.
Well, what was your service like at the State Department?
Well, I was on the Secretariat of the UN conference, and I was on that part of it that was concerned with drafting the statute for the International Court of Justice.
Were you at the conference in San Francisco then?
Oh, yes, I was there.
That must have been a very exciting thing.
3 months. Oh, yes. It was a great time.
Yeah. And did your work on the statute survive in reasonably good order, or was it substantially revised in the political process?
I think it survived. A lot of people were working on it.
Now, after you finished with the State Department, how long were you in the State Department, by the way?
About 3 months. I decided while I was there, Truman had become president very shortly before, and people were talking about how politicized the Justice Department was going to become, and so on. So I decided not to go back to Washington. I just stayed in San Francisco.
To digress for a moment, what was Alger Hiss like to work for?
I had very little to do with Alger Hiss once I was hired.
All right, you stayed in San Francisco, and what did you do then?
Well, I went to work for a law firm. I interviewed a number of law firms, and I was a pretty welcome commodity at that particular time. So I had a number of offers, as it were, except for one firm, which is no longer, Brobeck, Flager, and Harrison, where the senior partner came out to the elevator as I was about to go and said, well, if you decide to stay in San Francisco, we'd be glad to hear from you. And I said, well, my problem is that I can't decide to stay in San Francisco until I have an offer of a job. And he said, young man, at this firm, we receive applications. We don't make offers. So I never went back to Brobeck, Flager, and Harrison.
You ended up at Pillsbury, Madison,
Well,
and
I went
Sutro?
to Pillsbury, Madison, and Sutro, where I was offered a job. And I decided that it was much too big a place. It was the largest law firm west of the Mississippi at the time. I didn't want to be part
How
of
large
such a
was it
big
at that time?
organization. It was 55 lawyers.
A giant.
So for a year, I joined a delightful group of 3 men who had a small admiralty firm in San Francisco, and spent a year as their young man, hoping for collision cases and so on. But after the end of that, I decided that I had larger, or more interesting, not more interesting, but that it would be more suitable to my intellectual objectives to join. I went back to Pillsbury, Madison, and Sutro.
How long were you there?
About 3 years.
And what did you do after that?
I went down to Stanford to teach.
Was there an antitrust course at Stanford when you arrived?
No.
Did you start one?
I started on a small scale. I had a seminar which I taught for several years. One of my first students in that seminar was Bill Baxter, who later became head of the Antitrust Division.
A distinguished student.
A distinguished student,
yes.
Yeah.
Was the seminar on a particular part of antitrust, or was it a general seminar?
Well, I think it was general. I don't have any very clear recollection of it. I learned a lot more about antitrust afterward.
Most of the students have any background in antitrust, or was this their first exposure to it?
No, it would have been their first exposure.
How did it happen that you left Stanford for the University of Chicago Law School?
Well, I was thinking that I wasn't being a productive enough scholar at Stanford, and Chicago is a very intense place, and I thought would be very good for me. But it was really just that Edward Levy called me up and persuaded me to come, but I was kind of ripe to be plucked at that point.
And you moved to the University of Chicago about 1962?
Right.
And when you got to the University of Chicago, did you start teaching antitrust?
No, I didn't start teaching antitrust until Edward Levy stopped teaching to become provost of the university, and then I stepped into the spot. He had been teaching antitrust with the great economist Aaron Director for a number of years, and so I taught antitrust for a number of years. I would teach the class 2 or 3 times a week, I can't remember which, and then Aaron Director would take over for a class and give them an economic point of view.
Now, Aaron Director is an iconic name in antitrust. What kind of a man was he?
He was a great man. Great teacher, not a noted scholar in his own right, but through other people who were his students, he really contributed a great deal to the understanding of antitrust law. Interesting thing about Aaron Director, he was one of the great founders of the so-called Chicago School of Antitrust. Judge Posner added a lot to it when he came along. But they had very, I think, some significant differences in outlook. Aaron Director was a great skeptic and spent much of his time showing how foolish the courts were in talking about antitrust, whereas Dick Posner, I think, is mostly tried to show that the results, at any rate, of the court's decisions made a great deal of sense. So they contributed different things.
Personally, what kind of a man was Professor Director?
Well, he was a mild, quiet kind of man. He was Milton Friedman's brother-in-law, and Milton had a lot of influence on him. I think Aaron had a lot of influence on Milton.
Now, at some point, you became dean of the University of Chicago Law School. When did that happen?
That happened just a year after I arrived.
Even though you came there to get away from being dean?
I came there to escape the prospects of a possible administrative responsibility.
Well, how did it happen that you changed course and became dean?
Well, Edward Levy called me down and said he was leaving to become provost, and he thought that I was a very likely successor, and he didn't want me to resist it.
And you didn't.
Well, I was chairman of a search committee that looked very hard for another dean.
Finally, they decided they'd look close to home, right?
Right.
How long were you the dean?
12 and a half years. I sometimes say an eighth of a century.
And then you retired as dean.
Then I retired as dean.
But stayed on as a professor?
I stayed on as a professor, yes. Although, just as I was about to retire as dean, I was called by Friedman and Coven in Chicago. Said they were about to get an antitrust case, and would I be interested in spending a summer working on it? And I said I'd be very much interested. I learned later that he had been tendered the possibility of the case, but the friend of his who did that said, "What would you do if I gave you the case?" And he said, "Well, I'd try to get Phil Neal to help out." So he put the two things together, and that was the Seeley case. I went down to spend the summer working on the Seeley case, and worked on it for 15 years.
While still teaching at the law school?
Yeah, dividing my time, yes.
And then you left the law school in 1985 to found your present firm?
Yes. Well, in the meantime, yes. Yes, I joined.
But in the meantime, what?
Well, I had been at Friedman and Coven, and then a number of us at Friedman and Coven decided to withdraw, and we teamed up with a small group from another firm. We had clients in common, and we started the firm of Neal, Gerber, and Eisenberg.
How did you happen to become chair of the White House task force that resulted in the Neal report?
I have no specific recollection other than the fact that I think I was called by Joe Califano, who was Lyndon Johnson's counsel or chief of staff or something, and asked to come down and asked me to be chairman of this group.
And how was the group selected?
Well, I think the White House selected the members. I probably had some say and maybe made some suggestions, but by and large, I think they selected the group. And it was a very good group.
And how long did this work last, from the time the group got together until you issued your report in 1968?
About a year. And I must say, looking back on it, and this has given me an occasion to review the report, I'm really very much impressed by what we did. I think it turned out to be a splendid example of a law reform report. I think any law revision commission would be very pleased to have produced something that good. And much as I am an admirer of the American Law Institute, they spend many years on projects that I think are less, not any better than that report was.
Did you write the report?
No. I mean, I had a significant hand in drafting it, but we had a very excellent executive director named S. Paul Posner, who's I think still a lawyer in New York, who was a young man at the time, and he did a great deal of research and a great deal of drafting on it, and really deserves a lot of credit for it.
Phil, can you summarize for us what you think were the most important recommendations of the Neal report?
I think there were two, really, and we, as you know, we embodied our recommendations in the form of statutes just to give ourselves the exercise of really making the recommendations concrete. And one was a statute to deal with the problem of so-called concentrated industries, and the other was a statute to deal with the problem of conglomerate mergers. Those were the major recommendations. Although among the other recommendations was one for pre-merger notification, which is one recommendation that got enacted and is now the Hart-Scott-Rodino Act, which I think was a very important development.
Well, going back to the question of concentrated industries, Can you tell us a little more about the specifics of your recommendation?
Well, specifically, the recommendation, it was a quite elaborate draft statute. It was for a statute that permitted the courts to break up the largest firms in highly concentrated industries, with quite specific guidelines about how to do that. One of the things that interested me going back and looking at the report was that we recommended a special antitrust panel of judges, which was a recommendation that I think was drawn from the Section 1407 statute creating the multi-district judicial panel. That was a statute that I think I actually was the principal draftsman of.
Was that before or after the Neal report?
That was before the Neal report. That was when I had worked as executive.
I'd like to come back to that, but let's stick with the Neal report for a moment. Would it be fair to say that the recommendation with respect to concentrated industries required, or empowered at least, the breakup of firms based on their market share without regard to the underlying economics as to how they got there?
That's correct. That's correct.
Sort of a bright line test.
The idea was to have a bright line test and give clear guidance as to the cases in which you attempt some deconcentration.
Did that committee consult with Professor George Stigler of the University of Chicago Law School?
Well, George Stigler was one of the principal witnesses or experts that we consulted. He came and met with the committee, and I think it was really on the basis of George Stigler's views that we adopted this recommendation for deconcentration.
Were those views on the relation between profitability and concentration?
They were. Yeah, they were views which he had expressed in several articles, as I recall, saying that the maximum efficient size of firms was probably much smaller than many firms in concentrated industries, and that the competitive performance of the industries would be enhanced if they were broken up.
Was the concern that if they were larger than that size, the possibility of monopoly profits?
Yeah, it was a widely held view of so-called oligopolies and concentrated industries that their profits exceeded what a competitive level of profits would have been.
Now, when President Nixon came into office, he appointed another panel headed by George Stigler that reached a different conclusion, did it not?
Yeah, I think that's right. But some significant things had happened in the meantime, and one of the most significant, and I think a very influential development, was that Yale Brosen, an economist at the University of Chicago Business School, was stimulated by this to do some further studies about profitability in oligopolistic industries, and his studies tended to show that they were not more profitable. I think that had a big impact on the general outlook on the problem that our concentrated industry statute dealt with.
Did it affect Professor Stigler's view, as far as you know?
Oh, I think so, yes.
How about your view? Did it affect your view?
Surely it did. And I became much more skeptical about desirability.
Now, going back to the conglomerate merger question, that also involved a bright line test beyond which the market shares could not go. Is that not correct?
Well, not really. It didn't deal with market shares. It was really an effort to say that the views that some courts were taking and maybe politicians of trying to stop conglomerate mergers were not well founded, and that it was not a problem that could be answered by economic analysis. What the conglomerate merger statute did was to say, look, if you're doing a conglomerate merger in a highly concentrated industry, we'd like to push you farther down the ladder and acquire a firm that's not the leading firm in the industry. But it really was an effort to divert preoccupation with competitive effects and to say that it was not that kind of a problem.
Now, one of your other recommendations was to modify the Robinson-Patman Act. And in his dissent, Judge Bork said, you really believe it ought to be repealed, and you ought to say so. Was it the general view of the committee, as far as you know, that the Robinson-Patman Act should be repealed?
Well, I think the general view was one of great skepticism about most of the Robinson-Patman Act, but that it was felt not practical, really, to suggest repealing it.
Would it be fair to say that your recommendation was designed to modify the act and get rid of some of its excesses in a way that might be politically practical?
Correct. I think that's a fair statement.
Now, you had an interesting recommendation in there on improving the flow of information, which, in hindsight, was very much an avant-garde view of the importance of information in a competitive economy. Could you tell us a little bit about how that recommendation came about and what you had in mind?
I don't know that I can amplify very much, except to say that the reporting of company statistics was not really directed. I mean, there were. I think the SEC was beginning to require companies to report by division, or maybe the Census Bureau did, but none of the required reporting was specifically aimed at the kind of issues that would shed light on competitive problems. And we thought a lot could be done to improve that, which I assume has occurred, but I don't know in detail.
Well, there certainly is a lot more information being given out by corporations than there was at the time you wrote your report.
Right, yeah.
You were talking earlier about the coordinating committee of the U.S. courts that you served, where you served as the chair again.
Yes.
How did that come about?
That was a committee that was formed in the early '60s to cope with the massive group of antitrust cases brought against the electrical equipment industry. And I'm not exactly sure how the coordinating committee came about, except that Judge Ed Robson in Chicago was an influential figure and became chairman of that committee, which was composed of a group of judges from across the country who had some of these cases.
Was it originally a committee to coordinate the administration of those cases?
It was a committee to coordinate, yes, to coordinate the discovery phases of those cases.
And what was your role in it?
Well, I was designated executive secretary, and I met with the committee a lot at various places all around the country, discussed the problems with them, I can't remember having done a great deal of detailed work. There was a very efficient secretary, Margaret Dugan, who really handled most of the paperwork and whom I later hired at the law school. And then there was a lawyer named Perry Goldberg who worked with her.
And did the time come when the work of the coordinating committee went beyond the electrical equipment cases?
No, only in the sense that the committee formed the view that the structure that they had developed for dealing with the electrical equipment cases should be made permanent and embodied somehow in a statute. And that led to the formation of what is now known as the multi-district panel, the Judicial Panel on Multi-District Litigation. And as I remember, I was the principal draftsman of that statute.
Well, that was a major step forward.
Well, it was a step, certainly. I guess it was a step forward, yeah.
Was any consideration given to consolidating cases for trial as well as for discovery?
Oh, I think the judges who recommended that statute were firmly of the view that the consolidation of cases should be only for discovery purposes, and that the close of the discovery phases, the cases should go back to the court to where they were originally filed. And then the multi-district panel sort of jettisoned that idea at one point and began transferring them for trial purposes, and the Supreme Court reversed that and said that wasn't what the statute meant.
Phil, what are your thoughts on the importance of antitrust today?
Well, I think it's much less important than it may at one time have been. I think the widening of markets to international markets has had a great impact on the likelihood of anti-competitive actions by firms. I think the pre-merger notification and the Hart-Scott-Rodino process of taking a close look at mergers is important. I think it's probably highly important to have a strong rule against price fixing. And beyond that, I'm not sure that antitrust laws are very important.
There's been a lot of discussion about the importance of unilateral action by dominant firms and its possible pernicious effect. Do you think this is an area in which the antitrust laws have work to do?
Really, no. I mean, I know there's great interest in that, and there are interesting theoretical problems, but I think the hazards of interfering with efficient operation are considerable, and that the antitrust laws ought to go very slow in dealing with such problems.
I think there's danger of bad law as much as of beneficial law in this area?
I do, yes.
What is your view on class actions today, particularly antitrust class actions?
Oh, I think they're a bane of the judicial system.
You're talking about antitrust class actions or class actions in general?
Well, class actions in general and antitrust class actions in particular.
What do you think of the enforcement of the antitrust laws by the state's attorney general?
Oh, I think it's pretty deplorable. I would have held that the Sherman Act preempted state laws, and I guess we went off the track with Parker v. Brown way back when. It seemed to me there's a good case for saying from the beginning that the Sherman Act preempted state law dealing with competitive problems. And certainly the rise of the state attorney generals as a force in this field has been a very bad development in my judgment.
Why do you think it's bad?
Well, it makes for conflict between what the state attorney generals want to do and what is sensible from a national standpoint.
It makes it difficult to have a sensible national competitive policy. Is that your view?
Absolutely, yeah.
Is there anything else you'd like to comment on before we close the interview, Phil?
Well, I don't think we should close it without mentioning Ronald Coase, who's been I think, a very major force in the understanding of antitrust laws. I say that partly because I was responsible for Ronald Coase's appointment to the University of Chicago law faculty as the successor to Aaron Director. But Ronald Coase has brought yet another dimension to the whole problem. Ronald has been interested in what actually happens in industries, with particular emphasis on contracts and what accounts for various contractual provisions. And he's been responsible for launching a kind of whole new empirical study field in that area.
Phil, it was a pleasure visiting with you today, as it always has been.
Well,
Thank
it was a pleasure being with you, and I'm happy to have been here.